Well, thank you for joining us today. My name is Bob Nichols. I'm a partner with the law firm of Bracewell in Houston, Texas. I practice labor and employment law for employers and have for 33 years. I have the honor of working with a very bright associate attorney, Caroline Melo. She and I have worked together for 3 years. We're here to talk to you today about pay transparency and, in particular, new pay transparency laws in various states and localities. A couple of administrative matters. First of all, if any of you have any questions, in one of the upper corners of your screen, you will see a box where you can type in questions. Any questions posed, I promise that Caroline and I will answer them in the day or so after our webinar, and we'll send you an answer on our nickel. Please submit any questions you have. We always enjoy having the opportunity to answer questions. Our topic, again, is pay transparency laws. This is a very difficult issue for our clients, in part because management finds it very intrusive for having to disclose this information, for example, to candidates who don't even work for the company yet. It raises a variety of troubling issues, but as these laws proliferate, it's something you've got to understand. Let's start by letting me pitch to Caroline to give you the big picture. Caroline?
Thanks, Bob. So while the main topic today that we're discussing is pay transparency, I do want to just take a minute to talk a little bit about, where this all began. And it kind of, really comes down to the topic of pay equity. And this is where these pay transparency laws, these no salary history bans have really stemmed from. So pay equity is the concept of compensating employees who have similar job functions with comparable pay, regardless of their gender, their race, ethnicity, or other status. And in recent years, a number of states and localities have passed laws that prohibit asking an applicant about their compensation history or relying on that compensation history when setting a new hire's wage or salary. And these laws really seek to effectively combat pay discrimination, especially for females, minorities, or other individuals in protected groups, many of which likely started their careers at lower salaries or wage rates. And whenever they're asked about their salary or salary history, they're again locked into that lower wage or that lower salary. I know personally, since I've been applying for jobs since I was young, I have for sure answered that question on job applications before of how much money I was making or anything like that. So in addition to these statutes and these legislations that we're seeing, we're also seeing some lawsuits kind of create some case law for us in this realm. A recent Ninth Circuit case in 2020, Rizzo versus Yavino, is a great kind of illustrative example of the recent changes in law and the practical effects on employers. In that case, the Ninth Circuit held that employers could not use prior pay, quote unquote, alone or in combination with other factors as a defense to an unequal pay claim under the Equal Pay Act. And I'm going to tell you a little bit about the facts of this case just because I think it's a really good illustrative story of the issues we're dealing with here. So in Yavino, a California teacher, she filed an Equal Pay Act claim against her school district challenging their compensation system that set pay for new employees largely based on a formula from the incoming employee's prior rate of pay. And this teacher, she was hired as a math consultant. She had multiple master's degrees, had been teaching for, I believe it was about 13 years. And a male employee was newly hired, and she found out that that employee was making substantially more than her. And the school district, they admitted, they said, yes, this employee makes more than you, but we are basing your salaries on this formula that's based on your incoming pay or your prior rate of pay. And they said, that's not discriminatory. The court disagreed and said, no, you cannot alone or in combination with other factors use someone's salary history to set their pay. That is discrimination under the Equal Pay Act. So we're seeing many states enact these sorts of laws. I think right now we have about 21 states that have enacted some sort of compensation history ban. They're all a little bit different. We have many different cities and municipalities following suit. Several of them are listed out here. And just practically speaking, if you're in a state or a jurisdiction even that doesn't have these laws, you probably want to remove it from your application. We're seeing, a lot of employers we work with are just completely taking it out. It's becoming something that you're just really not going to see anymore in applications. It's a little bit too much of a slippery slope. And states and cities left and right are really enacting these salary history bans. And really, what purpose does it serve to be asking that? And then in addition to this no salary history kind of law part of this pay equity movement, many states have also passed laws protecting employees' rights to talk about their salary, talk about it with either other employees or other individuals. Of course, non-management employees already have this right under the National Labor Relations Act, but this right has very much been expanded. And some of these pay transparency laws that you'll hear Bob and me both talk about include some of these disclosure protections for these employees. So I'm going to pass it back over to Bob to talk a little bit more about some of the recent pay transparency laws.
Well, thank you, Caroline. I want to begin by talking about the state of California. And it's hardly shocking to hear that this new type of law has its origin in California. I read recently that the business publication Marketplace, in talking about these issues of pay transparency laws, called California the bellwether for changes to pay and employment laws. And that was the case here. In 2017, the California legislature passed Assembly Bill 168 that included one of the provisions that Caroline talked about that prohibited inquiries into salary history, but also included a separate, very novel provision, novel at the time, which indicated that applicants, after their initial interview, could ask the employer to provide a pay range, a high and low number for the potential pay. It also provided that employers had to keep all the records of those requests and pay rates and job classifications for up to 3 years. It also allowed employees to either file a complaint with the DFEH, California Division of Labor and Employment Standards Employment, or file a civil lawsuit. Governor Brown, the governor at the time of California, signed it. The support for the bill was overwhelming. One of the primary sponsors commented that I do this for my daughter, making the point that her daughter was starting her work life and that if her daughter was disadvantaged with regard to pay levels at the start of her work life, she would likely be disadvantaged for the rest of her career in terms of what she was paid. Notably, these pay transparency laws enjoy overwhelming public support in polling. So while you and I might find this topic difficult and complying with these laws bureaucratic and time consuming, the public overwhelmingly supports pay transparency legislation. And that point was made by the sponsors in California. What was important about the early laws passed on pay transparency, starting with California, is that the duty to provide the information was triggered by a request from the applicant. Soon after the California law, we saw Connecticut follow suit, and they passed a pay transparency law that provided that for employers within Connecticut, and that means one or more employees in Connecticut, they could not refuse or fail to provide applicants with the wage range for a position that they'd applied for upon the applicant's request or upon an offer of compensation by the employer. So a little bit different, the triggering event, than in California. Additionally, employers may not refuse in Connecticut or fail to provide an employee with their wage range upon hiring, upon a change in position, or upon an employee's first request for a wage range. The Connecticut law provides for various remedies, not only a private right of action, but also the right to file a complaint with the state labor commissioner. But what's important about Connecticut is it sort of followed suit with California in the sense that the duty to disclose pay range was not automatic. It had to be triggered by a request. And again, soon thereafter, we saw a law in Maryland with a similar structure. The Maryland law provides that upon the request of an applicant, an employer must provide a wage range for a position. Interestingly, the Maryland law, and we've seen more of this as Caroline will discuss, includes an anti-retaliation provision. So if an employee makes a request and then the employer reacts badly and doesn't get the job, that would be unlawful retaliation under the Maryland law. Now, the story changes dramatically in terms of how these laws are structured in 2020 with the passage of the Colorado law. At this point in the story, I'm going to turn things back to Caroline to tell you about the Colorado law and subsequent developments in other states. Caroline?
Thanks, Bob. So as Bob mentioned, the passing of this pay transparency in Colorado in November 2020 was really kind of the redirection of the course of pay transparency laws and amplified the requirements and the obligations employers were supposed to meet. So we kind of had this era of you have to disclose a wage or a salary upon request, and Colorado really changed that. And after that, we see kind of some different type of pay transparency laws coming into play, which we'll talk about a little bit more in a second. So the Equal Pay for Equal Work Act in Colorado was passed in November 2020, became effective January 1, 2021. And it has kind of two different parts that we'll talk about. There's a kind of a promotions part for current employees of Colorado employers. And then there's also a job applicant job posting part, which is, a little bit more on theme with what we're talking about today. But so for the promotions part of the law required that any employer with at least one Colorado employee, and that's really important for this law, at least one Colorado employee, prior to making any promotion decision, must make reasonable efforts to announce, post, or otherwise make known all opportunities for promotion to all current Colorado based employees on the same calendar day. So, what they're really trying to say here is we want to make all promotions available, regardless of maybe your gender, your another protected characteristic. We want to kind of create this even playing field. There were some exceptions though. So they said, you have to promote this promotion, but you can state that applications are only open to employees with certain qualifications. So you're not having to offer the job just to anyone. And then there are some exceptions that they created as well. So, you don't have to announce this promotion or this job opening when there's a compelling need to keep a particular opening confidential. So, for instance, maybe the CFO of a company is going to be terminated. We obviously maybe don't want that CFO to know they're going to be terminated, and you might already have someone kind of slotted to take their spot. And that would be a situation where there is a compelling need to kind of keep that opening confidential. The second exception that the law provides is in the case of a written representation. So that would be maybe an employment contract, an offer letter, maybe a policy that says, you start in X job, you're there for 1 year. Upon your 1 year anniversary, you're promoted to Y job. And you do not need to post kind of that, or you don't need to announce or post or make known that promotional opportunity. And then the third exception is the position is being filled on a temporary basis. So when it's kind of a temporary basis for up to about 6 months, and the hiring is not expected to be permanent, you don't need to announce that. So say you're having maybe an interim VP of HR that's coming in, you don't need to kind of announce that promotion. But let's move on a little bit to the job posting side of this Colorado Act. This is really, I think, the main part that y'all are going to be interested in. So again, if you have one employee in Colorado, just one, you must disclose in each job posting the hourly or salary compensation or a range of the hourly or salary compensation and a general description of all benefits and other compensation to be offered. This includes commissions and bonuses as well. And per the law, a posted compensation range may extend from the lowest to the highest range that an employer may pay. But this is in their good faith. You're going to see that word in several of these laws, their good faith belief that this is what they're paying for the job. So, and Bob will talk about this a little bit later, but you don't want to just kind of come up with some random range that could be litigated. You want to be able to prove we in good faith believed this was the salary that was going to be given for this job. As I said before, you also have to post a description of benefits. So that's going to be healthcare benefits, retirement benefits, benefits permitting paid days off, so sick leave, PTO, vacation, really any other benefits that are reported for federal tax purposes. Minor job perks, though, don't need to be posted in that. And this is really the key to this bill right here, is that it does not apply to employees or postings that are entirely outside of Colorado, but more specifically that are tied to a non-Colorado work location. But any job that could be performed in Colorado, even remotely, must include these requirements. So this is really where it gets tricky. So, say for example, I'm just going to think of, McDonald's. We all know what McDonald's is. Say McDonald's, they clearly have some in Colorado. They have some McDonald's in Colorado. So they have at least one Colorado employee. If they post a job for a cashier position at a McDonald's in Houston, Texas, they do not need to disclose the salary range, the benefits for that job, because there is no rhyme or reason that that job would be performed remotely, while this employee is maybe traveling in Colorado. A cashier has to be performed. It's tied to that restaurant, it's tied to that specific location. But, if McDonald's says, hey, we want to hire for, a VP of marketing, they're working out of our Dallas location, maybe a corporate office there, maybe that job can be performed remotely while that person's in their, house in Vail, Colorado. That technically would need to include the wage, the salary, the benefits. So that's really where it gets tricky. And we did kind of see several employers respond to this kind of law in a creative way of posting these jobs and saying, this job can be performed remotely anywhere except Colorado, or we'll take applicants from anywhere except Colorado applicants. And the Department of Labor and Employment in Colorado actually released some recent guidance that said a company that omits compensation by posting that a remote job is available for anyone in any location except for Colorado applicants is not compliant with the act. They've said that employers who restrict jobs, saying a Colorado applicant cannot apply, may be investigated by the department. They'll get cease and desist orders and potential fines. That guidance is surely to be litigated. It's really hard to know, how far can the agency really kind of reach in this situation. But this is where we're kind of seeing some kind of tension here of you want to be careful in Colorado. And, in addition to this Colorado or those requirements in Colorado, you also have to keep records of job descriptions and wage history for the duration of someone's employment or 2 years after. Aggrieved individuals can also file a complaint with the Colorado Department of Labor and Employment, and penalties are between $500 and $10,000 per violation. Okay, so let's kind of talk about our next state where they're in this post Colorado era. So again, they're moving a little bit from this request position to you must disclose. So Nevada employers are required to provide applicants with the wage or salary range or rate for positions in which an employee has or an applicant has interviewed. So again, this means that doesn't need to be posted on the job posting. So it's a little bit different there in Colorado than in Colorado, but there still is kind of that proactive disclosure that has to occur. But for current employees, employers must also provide the wage or salary range or rate for promotions or transfers of employees to new positions if the employee, one, applied for the transfer or promotion, two, completed an interview, or has been offered the transfer or promotion, and requested the wage or salary range or rate for the promotion or transfer. So Nevada, we're a little bit in that post-Colorado era. It's a little bit of a mix, but definitely a little bit more than kind of the just initial requesting requirement. In Nevada, it's a little bit the kind of process for filing a complaint in a civil action is pretty similar to when someone files, an EEOC charge or with their state agency. An employer applicant would file a complaint with the Nevada Labor Commissioner. They would issue a right to sue, and then they would have a certain amount of time after that to file a lawsuit. So the next state we're going to look at is Rhode Island. And this is, again, a little bit of a mix of the Colorado era pre and post. Beginning January 1, 2023, upon an applicant's request, an employer must provide the wage range for an open position. So we still have that little bit, that request aspect a little bit. But for current employees, it mirrors a little bit more of the Colorado law. So the law requires that if a current employee transfers to a new position within the company, the employer must provide the wage range for the new position during the transfer, even if the employee does not request it. So there's that piece of you have to disclose it even without a request. Further, there is a retaliation provision included in this law, which we don't see in all of the laws. We're seeing it more kind of in this post-Colorado era. An employer cannot refuse to interview, hire, employ, or promote an individual or retaliate against an individual because they requested a wage range. And fines here range from about $1,000 to $5,000. There's also a private right of action in addition to filing a complaint. Rhode Island, though, it does provide actually a good amount of damages in a civil action. There's special damages, compensatory damages, liquidated damages, even punitive damages are available. So, we definitely want to be careful there in Rhode Island. Okay, before we move on to some of the kind of cities and localities that are passing these laws, I want to talk about Washington real fast. So, and here we have a little bit of a current law, and we're going to have a change in 2023. So, under the current law right now in the state, employers must provide job applicants with the minimum wage or salary for the position sought, again, upon the applicant's request after offering the position to them. So, a little bit more delayed, again, upon the request. But starting January 2023, employers must disclose in each job posting the wage scale or salary range. And this is similar to the Colorado law, a description of all benefits and other compensation. So, again, that's going to be insurance, that's going to be PTO, that's going to be bonuses, that's going to be commissions. Washington, though, we're really hoping some more guidance is issued for this law. A lot of things are a little bit murky here. For instance, the law, it says it applies to employers with 15 or more employees. It doesn't specify, do all those employees have to be in Washington? Does it just need to have one in Washington? So we're hoping we get some clarity there. It's also pretty unclear about whether the law covers job postings for remote positions that can be performed in any state, which I would say for me and Bob, when we're talking about this, that's kind of one of the biggest questions with these pay transparency laws is what do you do with remote work? So we're really hoping that Washington kind of comes out in the next, hopefully a few months, hopefully before the January 1, 2023 day with a little bit more guidance on this. So, and then I do want to mention a few kind of localities that have passed some post-Colorado era laws. Most notably, New York City has passed a law which very closely mirrors the Colorado law. We'll talk about that in a second. But some other laws or some other localities that have passed laws are Cincinnati and Toledo in Ohio, as well as Ithaca and Westchester County in New York, and Jersey City in New Jersey have also passed similar laws. Okay, so a recent New York City law makes it unlawful for an employer to advertise a job, promotion, or transfer without including the minimum and maximum salary for the employer that the employer in good faith believes at the time of posting they will offer for that position. Open-ended salary ranges are prohibited here. So you can't say, here's the minimum salary or here's the maximum. You have to give kind of range on both sides. Specifically, the law applies to employers with 4 or more employees. So small employers will be brought into this, but you just need to have one employee in New York City. So very similar to the Colorado law here. You could be an employer with 4 employees. 3 of them are in Connecticut, but if one of them works remotely from New York City, you're brought in under this law. So that's really important to pay attention to. It also, in that 4 count, considers independent contractors. So again, you may have some kind of sneaky employees that you don't realize count under this number, and you need to take independent contractors into account. Employment agencies are also covered by the law, regardless of their size, but a temporary help firm, that's seeking applicants to kind of join their larger pool of people are not going to be covered by this. It would be a little bit hard for them to give specific salary disclosure. Under this law, disclosure of insurance benefits, PTO, are actually not required. So that's kind of where we differ from the Colorado law here. But just like Colorado, it does apply to remote work positions that can be performed at least to some degree. That's kind of the key language in New York City. So even if the employee resides somewhere else, but they could go work in New York City, that means it applies. So if you have at least one employee in New York City, you post a remote work job that potentially, I guess, could be done in New York City, then it's covered. You're brought in there. You need to disclose the wage and salary. Additionally, it also applies to postings for full-time jobs, part-time jobs, as well as internships and independent contractor positions. And we know, a lot of New York City employers provide internships. So that's going to be a big one here. The deadline to comply is November 1, 2022. It's actually previously a sooner deadline, and the amendment pushed it back a little bit. Aggrieved individuals can file complaints with the New York City Commission on Human Rights, but specifically, employees can bring civil lawsuits, applicants cannot. So, they're trying to prohibit people from just applying to a ton of different, different employers and bringing lawsuits over that. And then before we wrap it up, one thing that's important here is the commission has said, if an employer that violates this law could pay monetary damages, have to amend their advertisements and postings, update their policies, conduct training, provide notices of rights to employees or applicants, and engage in other forms of affirmative relief. But the commission has said it will assess no penalty for a first violation if the violation is cured within 30 days of complaint and service, which I think it's huge to me there. I'm, very thankful the commission kind of offered that in the law. But again, it has to be cured in those 30 days. And the commission has said if it's not cured, or if you have another violation, they could actually fine you up to $250,000. So there is a good amount of risk there. Okay, and before I pass it over to Bob, I'm just going to highlight really quickly two potentially future laws in California and New York State. There is a law that's passed through the legislature in California, but has not been signed by the governor yet. And we're seeing kind of mixed news reports of when it'll be signed or if. But the legislation would require employers with 15 employees or more to include pay ranges in each of their job postings and publicly report how much certain groups of employees are paid. So we're even kind of adding another kind of realm here, another kind of disclosure that an employer would have to do. It applies to third-party postings, and there are some record retention requirements as well. In the New York State, there's no current legislation right now. California, again, there is current legislation. New York, there's not. But in June 2022, the Senate introduced a bill which enacted would require employers to include a salary range and job description in each job advertisement if the job description exists. So it's very similar to New York City's law, except they may include kind of a fixed compensation. You don't have to have a range. Employers have to maintain records. Retaliation is prohibited here. But again, this is a little bit up in the air of, we really haven't seen specific reports of when this will be signed, if it'll be signed. But once it is signed, if it is, it will take about 270 days to go into effect. So employers will have a little bit of time to kind of get their job postings in order. And that's kind of it on our pay transparency law front. But I want to kick it back over to Bob to kind of talk about, what can you be doing here to protect your company and comply with these laws?
Thank you, Caroline. I'm going to close today with just a few remarks and pieces of advice about going forward. First of all, your company, in evaluating where you stand, needs to begin by asking in what jurisdictions do you have employees, what states, what cities, what counties. You need to remember we're not only talking about facility assigned employees, but remote employees as well. And from that list, you determine whether there is some application of one of these laws to you. Also, bear in mind that if you're going to allow remote work broadly in a variety of states, that may impact coverage too, because someone might take your job and work in a covered state. For a lot of companies that operate in a wide variety of states or all states, they're not going to escape the pay transparency, pay range laws. And they're going to need to come up with a uniform approach across the company. And they're probably going to look to the states with the most strict rules and use those as a template so that they can feel comfortable they're compliant in all states. And then they'll use a uniform approach across their company. A piecemeal approach where you only follow pay transparency requirements for jobs where they are covered by some local or state law is more problematic, obviously, for a variety of reasons. First of all, it's a giant administrative headache for your HR and management people to be applying different rules to each different opening. Also, taking a disparate approach for different openings in different parts of the country within your company, as many of you know, can create real serious morale and employee relations problems. If employees realize they're in a location that is being treated less beneficially in terms of disclosure than some other part of the company. If you feel confident you're going to be covered by some of these laws, you need to consider, are we going to have a single template again for all of these laws? Bear in mind that in some cases, in some states and localities, their law does not apply if you're simply filling a position without advertising for it, posting it internally or externally. That's not true everywhere. Places like Colorado, it's more complicated. So even if you're going to fill the job without posting it, you shouldn't necessarily assume that in every jurisdiction there will not be coverage, but that will be true in some jurisdictions. Also, in getting ready for compliance, you obviously need to audit where you stand on your pay practices and amounts. Bear in mind that once you start making these disclosures, people inside and outside your company are going to do those comparisons for you. And if they find disparities or anomalies, particularly those that at least appear to be tied to gender or race, you can expect that might be a business or even an employment law problem for you. So you're going to need to develop a methodology for setting these minimum and maximum ranges in jurisdictions where you are covered. Some employers may aim high in terms of their ranges because they want to appear attractive to candidates. The thing to be careful about is not to set artificially high rates and obviously create unreasonable expectations for candidates and your own incumbent employees. Lowballing your ranges will present its own set of problems, most notably from a competitive standpoint, particularly in the job market in which we live. If you lowball it, you may lose potential candidates. Recognize that if you are just outright dishonest or deceptive in the ranges you set, you should expect litigation, I think, at some point, somewhere, over those deceptive or dishonest range settings. Recognize that the information that you are going to provide is going to find its way probably everywhere. Candidates are going to share it among themselves. Employees are going to share it, where, for example, you have to make disclosures to current employees. They are going to post it online. Maybe Glassdoor will ultimately end up with a lot of this information posted. So you need to be ready for that eventuality, and you need to make sure your pay system and your pay equity is in good shape. Also, bear in mind that some of these laws require disclosure of things beyond simply wage or salary range. Some of these laws require disclosures of non-wage type compensation, such as bonuses and bonus opportunities. Some of the laws require descriptions of benefits available. Remember that also some of these laws have record-keeping requirements. And if you don't do what you're supposed to do, in some jurisdictions, you may be audited by a state or local agency. And if you haven't been following the law, they certainly will identify that and you'll suffer the consequences. Be very cautious about management or HR talking to competitors about what they are doing. As many of you know, if you communicate with other companies and in particular your competitors about how they're setting wages, benefits, you can easily violate federal and state antitrust laws. Remember that you're going to need to get control of your recruiters, because if your recruiters, inside or outside, engage in conduct contrary to these laws, you will be responsible for it. You're going to obviously need to train people, both supervision involved in hiring and HR. For example, again, if a supervisor expresses dismay when someone makes use of this information or talks about it or asks for it, the anti-retaliation laws applicable for some of these statutes may come back to bite you. Let's assume you're in a jurisdiction or jurisdictions where you think you can or you want to try and avoid any coverage or almost any coverage under these laws. For example, Caroline and I live in Houston, Texas. If you have all of your employees in Texas, including your remote employees, probably for the foreseeable future, you don't have to worry about these laws. But you need to consider where you stand. Remember, even though you regard yourself as, for example, a Texas business or a Florida business, if you have remote employees in other jurisdictions or you make jobs available that could be performed remotely in other jurisdictions, you may have coverage under one of these laws that you don't expect. When you set policies about allowing employees to work remotely in other states, you need to consider, among other legal compliance issues, the impact of coverage under these pay transparency laws if you allow remote employees to work in jurisdictions in which you're not already situated. Finally, again, you may think, well, we just won't post jobs. We won't advertise. We'll try and fill whatever we can internally just by putting Mary in that opening, giving her a promotion. That will work with some of these laws, but in some states, apparently like Colorado, that's not an out. And even in that instance, you may need to make disclosure about what you're doing. That's all we have today. I hope you found it helpful. We appreciate you joining us and have a super day.